So thank you all for attending this webinar. We are happy to host this in collaboration with the speakers who are present today. They are very rich in this area, and I hope advocates can learn something from this sensitization on the internet shutdown and digital rights from presentations. So I will just hand this over to, sorry, before I hand this over, kindly receive apologies from our chair, Ms. Helen Namisi, who's attending a parallel meeting and could not attend this webinar to give remarks, but she fully supports this sensitization, and we hope we can learn a thing or two from this session. So thank you, everyone. Magdalene, over to you.
Great. Hi, everyone, ladies and gentlemen. My name is Magdalene Waithera. I am an advocate of the High Court of Kenya. I practice with Wamboi Shadrack and Associates. I am also an Internet Shutdown Advocacy Fellow 2023 with the Advocacy Assembly. And it's a great honor to have all of you today as we have this discussion. The internet is not just a technological innovation, it's a social phenomena that transforms the way we connect, the way we interact, the way we learn. And it's recognized as an enabling right for international human rights, such as the freedom of expression, the freedom of association, rights to information, and other political rights. And so it's vital for us to safeguard it and to safeguard other digital rights. And someone would ask, I mean, in a country where we are grappling with a lot of challenges, such as harsh economic times and overtaxations and the like, why is it that we are focusing on digital rights? And we say that digital rights are a priority. In today's world, you can barely function without having the internet. Just looking at all the sectors, from education, from healthcare, every aspect of our lives today is governed by the internet. I mean, looking at such even more important discords that are happening in our country, you cannot have them without having access to internet. And even this discussion, I mean, it's powered by the internet. So, and of course, our very gracious partners. So we have to safeguard digital rights, and that is a priority. The freedom to enjoy the internet and usage of internet is, of course, at risk due to the constant threats by authoritarian governments in conjunction with private companies who constantly cause internet shutdowns. And during critical times such as electioneering periods or in periods of civil unrest, we get to experience very many countries having their internet shut down. In 2023 alone, at least 183 internet shutdowns were recorded. And looking at our neighbors even closer home, just in Ethiopia, in Tanzania, in Uganda, they've all experienced internet shutdowns in the last 2 years. And so we say, there's a popular Swahili saying that says that ukiona cha mwenzio chanyolewa lako tia maji. And so we have to start preparing ourselves. We have to equip ourselves with tools. So in the event that we experience internet shutdown, then we are better placed to challenge these and to be able to bring forth any tools that can be able to combat these. And that is why we are having this discussion today. And I am very privileged to have very wonderful speakers on board who will be taking us through the discussion. Our amazing panelists, we have Dr. Laibuta Mugambi. He recently completed his PhD in law from University of Witwatersrand in South Africa, where he was focusing on the adequacy of data protection regulation in Kenya. He's a Chevening scholar and holds a master's in law degree from the London School of Economics, where he specialized in human rights and international commercial arbitration. And of course, in Kenya, he's done extensive work within the digital space. So it's such an honor to have him today. We are also joined by Toby Mendel. Toby is the Executive Director for Center for Law and Democracy. And prior to founding the organization, he spent 12 years as the Senior Director of Law at Article 19, which is a human rights organization focusing on the freedom of expression and the right to information. He has provided expertise on these rights to a wide range of actors, including World Bank, the UN, and various intergovernmental bodies. And he's also worked as a senior human rights consultant for Oxfam, Canada, and often playing a leading role in drafting legislation in areas for the right to information and media regulation. And a bit later into the discussion, we'll be joined by Michael Aboneka. Michael is a practicing advocate from Uganda who specializes in the rule of law, democracy, and good governance, as well as combating climate change. He's part of the team that took the government to court in 2021 when Uganda experienced an internet shutdown, and is going to give us a bit more background on how that went and the kind of impact that that had. And so, without further ado, allow me to welcome our panelists who are already here, Dr. Mugambi and Toby. We can start with Dr. Mugambi, who will give us a bit of a background on what internet shutdown is and the legal framework that currently exists and why we should be having this discussion today. Thank you and welcome, Dr. Mugambi.
Thank you very much, Magdalene and LSK Nairobi branch for this forum. So internet shutdown has many meanings. It can be the overall inaccessibility of the internet completely, where you can't connect to any platform, notwithstanding whatever means. Then there's also internet shutdown that is a bit milder from that. So that is the extreme whereby nobody has access. Then you also have internet shutdown, like I think some of us experienced during the KCSE and KCP examinations last year. There are a lot of complaints that people could not access Telegram. So if you use Telegram, people realize that sending messages, especially photos and videos, was a big issue. And one of the explanations that was floating around is that there was some, because of those examinations and that this platform was the one being used for cheating, then it had to be throttled. So that, so it can also, internet shutdown can also be to the extent that a platform, it can be one platform, like we saw the problem with Telegram. In some countries, for example, like in China, you will not access certain platforms. Like in China, you can't access Google sites, you can't access Twitter, WhatsApp, etc., but they have their platforms for that. Some regimes also will block a specific site. Let's say, for example, a blog. You'll find that in some countries where there's an authoritarian regime and there are people who are very critical of the state, they'll make it very hard. They'll make it very hard for you to access a certain platform. I think a lot of us can remember when the last regime, the Jubilee regime, was in power and Uhuru used to travel a lot. Then there's somebody who established a website that asked just a simple question: is Uhuru in Kenya? And then that website will have the answer yes or no. Then it reached a point people could hardly access that site. It was a .ke, it had a .ke domain. And one of the explanations that were given is that there were too many people accessing, wanted to know whether Uhuru is in Kenya or not. So those are very different forms of internet shutdown, from extremes to where you have certain platforms or certain resources online you can't access. And then you have some that it may just be one website. The challenge with these shutdowns is that they cause some certain harms. So when you look at it, let's say, for example, you use for your business, you use Telegram, and Telegram was being throttled, so the speeds were quite low. So another way is that instead of shutting the whole internet, so if, for example, if in a country, if you enjoy speeds of, let's say, up to 50 Mbps, for example, you find that the speed is lowered by the state, that it becomes 1 Mbps or 0 point something Mbps. So the internet is there, but the speed is so low, the upload and the download speeds are so low that you really, it becomes that you can't use it. So there are a lot of harms that can come with, there are a lot of harms that can come up with this kind of internet shutdown. For example, there's of course the disruption of communication. If whether it's for personal reasons, whether it's for commercial reasons, whether it's for political reasons, so it becomes very hard to communicate. And we know we communicate for different reasons, for socialization, for economic purposes, for religious purposes, for political purposes. So you find that even emergency responders, humanitarian organizations, you find that the police, ambulances, etc., emergency services cannot operate, which are very critical. Then you and your loved one, for example, if you are communicating with a relative who was traveling and you want to know their well-being, you're not able. Then another problem is that it violates fundamental rights. In general, I think that's what I should have started with. It violates fundamental rights because freedom of expression, freedom of movement, access to essential services becomes a problem because of this either full or partial internet shutdown. Then, of course, now there's the economic impact. Banks, banks, insurance companies, even when you're paying at the till, at a supermarket, at a petrol station. So a lot of services have generally migrated online. And since they have migrated online, if there's an internet shutdown, it means these businesses cannot operate and you cannot seek these services. So, and there are studies that have been done before that shows that this shutdown or throttling of the internet has big economic impact. So some people usually see that we are doing this because for national security, for a public emergency, but we rarely look at the economic impact of this shutdown. Then something else, of course, is education disruption. If people are, schools that use online facilities for their teachings and they're not there, the education is compromised, health challenges. I think I've talked about health challenges, social impacts, political impact. So if the shutdown is due to politics and the throttling of the internet, then you cannot undertake your political activity, therefore limiting your political rights. So there are all these harms that can be brought about. But then, you ask the third question to you ask is that what laws do we have that can protect against this situation? Of course, first is the Constitution. Our chapter on fundamental rights and freedom, first chapter of the Constitution, lists all these fundamental rights and freedoms. And when you shut down the internet, whether it's a complete or partial shutdown, it has effect on the right to life, the right to health, the right to education, the right to freedom of movement, dignity, discrimination, etc. So there's all these provisions that you can argue. If you shut down the internet and these harms are occasioned, then it means that you are limiting our fundamental rights and freedoms in this way, in this or that way. And so the thing is that in Kenya, I think what we need to make in Kenya, apart from that, is Uhuru in Kenya and the Telegram issue, we really haven't had an internet shutdown that we can say has had impact. But the good thing is that we have a lot of court decisions that have argued about against state action that unnecessarily or unjustifiably extrajudicially limits fundamental rights and freedoms. For example, the courts have put forth the argument of proportionality, where you need to look at action by the state or any legislation that is coming. Is it necessary? What are the potential harms? Is it provided by the law? Are you limited fundamental rights and freedoms? What is the balance between the harms and the benefits that this action is meant to take? So, in as much as we don't have a specific provision that will say do not shut the internet, but we have provisions of the Constitution that could be used in the event that this shutdown has negative impacts on the fundamental rights and freedoms of Kenyans. Magdalene.
Yes, Dr. Mugambi. And maybe we can go to Toby. How does, what is the role that strategic litigation plays in advancing digital rights?
Thanks. So Magdalene, I had prepared like about 20, 25 minutes presentation looking at the role of litigation and strategies for litigation. Shall I go through all of that, or just talk about the way that strategic litigation can impact on shutdowns, and wait with the case strategy for later? Just advise me, please, on that issue.
I think you can combine that with the strategies.
Okay. Okay. So sorry for that introduction, but welcome. Not welcome, but thanks for inviting me, and great to see everyone here. I'm based in Eastern Canada. And we got about 60 centimeters of snow over the weekend, so we're still shoveling out, you know. So I think the context here a little bit different, probably, than over there in Kenya. Let me start just by painting a little bit of a picture, and Mugambi, I think, described very well the different negative impacts of shutdowns. But let me just talk a little bit, and Magdalene mentioned, the number of shutdowns. According to Access Now, in 2022, there were 187 shutdowns in 35 countries. But I think it's interesting, and including obviously in Eastern and Southern and across Africa. But it's interesting to look a little bit at the profile around the world of these shutdowns. So according to Access Now, China has only had one internet shutdown in 2019. It's true, as Mugambi mentioned, that many services that we consider to be absolutely fundamental to using the internet, including Google and things like that, are not available in China. But in some cases, those services have themselves withdrawn from China because they didn't feel that they could operate there given the human rights situation. So, I mean, obviously, China is not a democracy, and one might assume that that would be a country with a much larger number of internet shutdowns. But the simple fact is that China can control the internet and can control the use of the internet internally, basically without resorting to shutdown. So it doesn't need to go there. It's not a measure that it needs to apply very often. Russia, according to Access Now, has had 4 internet shutdowns overall, and one of them is ongoing. That's a severe and serious shutdown. That basically started with the Russian invasion of Ukraine. So it was the war context, and Russia then, really clamped down on freedom of expression. Even though Russia, another country that's not a democracy, had exercised some control over free speech before, but now with the war, it's elevated it to a new level. So I think, this picture, and if we look around Africa, most of the countries in Africa, with some notable exceptions, either they've never had an internet shutdown, or they've had one, or they've had 2. Only 4 countries in Africa, again, I'm relying exclusively on Access Now for this information. Only 4 countries have current shutdowns in Africa. I mean, only, that's 4 too many. Obviously, not a single shutdown should be experienced, but still. But then, if we look, Ethiopia, for example, has had 10, including a current one. Sudan, 30, including a current one. And then just to mention, I mean, if we go to India, which is sort of in a league all of its own in terms of internet shutdowns, 299 shutdowns, including current shutdowns. So, and India is a democracy. I mean, there's a big debate about what's happening in India and where it's going with its democracy. There have been challenges in recent years, but, it has elections, it changes government. And so, it uses internet shutdowns much, much more extensively because it relies on that type of control compared to, what's going on in China. I just wanted to give that as a little bit of a taste, if you will, of the global picture on this. I was going to say a couple of words about the different forms that these take, but Mugambi has really gone into that very well. I think, and when we talk about litigation strategy, obviously, thanks for that, Mugambi. Obviously, it depends on the type your litigation strategy it needs to be tailored to the type of shutdown you're facing. And the different contexts from that, and I would just, very briefly at this point mention, the legal context, if you will, for those shutdowns ranges from cases where the government openly and legally, according to administrative law, at least, shuts down the internet. It says we're shutting down the internet, we're using this legal regime, and we're doing it for this reason, to cases where the government shuts down the internet, but illegally because it doesn't actually have any basis in law, to cases where the government shuts down the internet but then denies that it's done that. So, the internet is shut down in one of the many ways that Mugambi described, but the government denies that that's happening at all, or it may blame it on other actors or on other phenomena. For example, it may say, this is a weather-related disruption. We're not shutting down the internet. It just is some weather system. Or it may say that, the internet service providers are the reasons for the shutdown. So, the claims that, and sometimes the fact patterns that are underneath those claims vary considerably. And of course, that also will impact your litigation strategy very significantly. I do just very briefly want to cast this in a slightly wider context of digital rights and digital issues, much broadly, because of course it's part of that overall environment. And I think, I don't want to have feel free to ask questions. I don't want to get into a long discussion about this. I could spend days on talking about digital rights issues, the very multifarious, complex topic. But I think that, broadly speaking, we do have to recognize that we have a problem online. There is a lot of bad speech out there which is causing harm to our societies. Internet shutdowns cause serious harms of their own, but the internet, when it's working properly, also occasions a lot of harms. I'm thinking of things like hate speech, like driving, different types of speakers, most particularly women, but other, minorities and racial groups and ethnic minorities, and all kinds of attacks on different kinds of speakers, disinformation, which at the levels that it exists in almost every country today, is really causing serious problems to our society, to the point, for example, where even in my own country, Canada, which is a fairly well-established, well-organized, electorally solid democratic country, but we're getting to the point where ordinary citizens are quite confused about some basic facts of what's going on in our country, and the disinformation is so prevalent that it's causing that phenomenon, such that when people go into elections, yes, the technical apparatus of elections is free and fair, but if people don't actually know what's happening in the country because they're hearing so much disinformation, then the election isn't working in the way that it's supposed to. And if we think about free speech, one of the most important rationales that has historically been put forward for free speech is that, ultimately, in an equal playing field, in other words, where free speech is protected, the truth will win. But that's not what's happening in the current environment. So, and states are taking different kinds of measures to address this problem. Some of them are ineffective and repressive, basically banning, the false news, for example. And I would be interested if anybody on this call will put up their hand and say, I have never in my whole life ever told a lie. You can't criminalize ordinary behavior. We've all said things which aren't true. We don't criminalize that sort of thing. That that's not what the criminal law is for. And then we see other initiatives. For example, the EU has passed the Digital Services Act, which takes a much more structural approach, which basically requires major online platforms, among many other things, requires major online platforms to do annual assessments of the human human rights impact of their operations, and that's the word used in the act. That's everything, what they're doing in their companies, and how that impacts on our freedom of expression, our privacy, our elections, our health, our equality, and all kinds of issues, human rights issues like that. And then when the companies do that assessment, they're required to address those things. So that's a more structural approach to addressing these things. So I mean, that's the sort of broader context for that. In terms of what is the role of strategic litigation on shutdowns, and strategic litigation generally, I would say, but specifically around shutdowns, it has two different areas of impact. One is the legal one. So, I mean, it is litigation. It's a case in a court. So that's a legal phenomenon. But it also has especially if it's done properly and if it's accompanied by an advocacy strategy, it also has a much broader political or advocacy component. So I mean, I think we need to always keep in mind as we're thinking about strategic litigation, not only the narrow legal side of things, but also you may completely lose your case in court. Court may say, decide absolutely 100% against you. You've lost it. But you may win your case because the social and political and advocacy impact of your case was so significant that the government actually stops the shutdown, which is what you wanted. So I mean, strategic litigation cases are done properly, if they're accompanied by strong advocacy, can have all kinds of different impacts than just the legal one. So I think we always need to keep that in mind. Okay, drilling down now a little bit into case strategy, and I mean, as Mugambi and started out saying, and I emphasized a little bit, I mean, the types of these cases are very broad. So there's not like there's one litigation strategy, one set of arguments that's going to win you this case. It really depends on the facts. But I think that, I mean, an initial consideration that you need to put some time and thought into is, are you going to do it at all? I mean, you need to engage in a cost-benefit analysis. Is the cost and the benefit, is it going to cost more than the benefit is worth? Basically, and even simply, do we, whoever we are, and I'm assuming that some of you are with NGOs and others are maybe practicing lawyers, do we have the capacity to do this? I mean, it's not a good idea to engage in something that you can't really complete, or you can't complete properly, or as you wish to do it. And in terms of the kind of the cost side of the ledger, legal cases often take a long time, especially if the government contests them vigorously. There may be interim measures that you can get more quickly, so you can get the court to make an interim order, for example. But you need to be thinking of a long-term strategy here. And for civil society organizations, and of course, as Magdalene mentioned, I run a civil society organization. We often think in terms of projects, and you're going to be awfully lucky, I would say astoundingly lucky, to get a project that is going to last you through the whole duration of a strategic litigation program. It just, they take longer than that. So you'll need to have repeated projects. You need to think about that if it's part of your part of how you're going to address this. And of course, they involve legal costs, which can be quite high. Lawyers are not cheap, professionals to purchase. You may have other ways of doing that. Then there will also, if you're doing it in the more holistic way that I would generally recommend, but of course not everything needs to be done that way, but there will be advocacy costs. Advocacy also costs money. You got to pay people to do it. You may have products involved in that kind of thing. So I think, you need to think about, whoever you are and whatever's motivating you, you need to think about the extent to which this litigation strategy aligns with your wider goals, especially if you're a civil society organization, versus you're just reacting to something. the internet, the government engages in an internet shutdown, and you say, okay, we're going to fight that. I mean, that's that's a legitimate thing. An internet shutdown automatically involves abuse of human rights. We're going to be made that very clear, but that doesn't mean that you automatically, throw your weight into a litigation strategy against it. I think you need to have alignment with your wider goals for that to be a good strategy for you. And you also need to think about other possibilities. For example, the risk that either you or the people you're working with may be subject to harassment or other kinds of pushback from powerful actors, from the government, from big companies. The governments that do engage in internet shutdowns, it's a dramatic thing to do. It's usually very, very visible. Governments that do it want to do it. They're not just sort of, oh, we shouldn't have done that, we'll stop now. They did it, they know that it's a big deal, they're determined about it, and if you stand in their way, they may do things which aren't very nice to you, whatever form that may take. And I mean, usually the public, if you're clever about it, you can bring the public on your side because the public are being negatively impacted by the internet shutdown. But that depends on the nature of the shutdown. For example, if there's unrest in a certain part of the country and the internet shut down there, the prevailing public opinion may be, oh, good, this is a troublemaking area or whatever. You may suffer a negative public backlash. So you need to think a little bit about that. Of course, in terms of the benefits, and I've already touched a little bit on this, I mean, it's not just a big win. You win your case completely and the court orders the government to stop the shutdown. There can be a change of political calculus, and that, I mean, that's the advocacy side of things. It can be, the case can make it uncomfortable for the government to continue or to, or to do it again if that's what you're worried about. Of course, it also, when you engage in litigation, it costs you, but it also costs the opposing party, usually the government, money too. So the costs may become prohibitive from you. And I mean, you may not stop the internet shutdown that's the subject matter of your case, but you may, and the government may have invested enough in that it's not going to stop it, but it may sort of say, okay, well, let's be more careful next time. So you may prevent future shutdown events. So I think that, there are, you can have incremental legal wins. For example, the court may establish conditions under which a shutdown is legitimate. So even if you don't win on that case, but you may, narrow the window for the government to be able to do it next time, the court may establish timelines. So instead of saying the shutdown's illegal, they say, okay, it was legal, but it served a purpose, but that's over now, or it will be over, or it will be over when these conditions are met, or things. And you may also get compensation for clients. So I mean, there's a lot of different possible wins there. And I think, yeah, let me go then to the question of planning an internet shutdown strategy. And I'm kind of I'm working from a kind of a high watermark position here. This is an all-out internet litigation, strategic litigation strategy against shutdowns. Not everything has to be quite as all singing, all dancing as this, but you should be thinking about identifying a hierarchy of goals. So the sorts of things I just talked about, getting the court to order the shutdown to be illegal, getting the court to stop the shutdown from now, other sorts of things. Map out your strategy linked to that. So, we want to achieve these goals. What's the strategy that we need to for that? And I mean, always, of course, based on a realistic assessment of what you think your courts will be willing to do. And what, based on how independent the courts are, how brave the courts are. As I mentioned, this is something that the government will automatically be fairly committed to. This is a big stakes game in most cases. So you need to select the right case and the right plaintiffs. And I'll come back a little bit to that. You need to map out the resources that you're going to use. You need to build the case. And that's, a little bit like any legal case. Lawyers know how to build cases. But here there's a wider set of considerations, not just the legal element of the case, but the advocacy, political side of it as well. Okay, in terms of the legal arguments, and some of the basic considerations that you need to think about, are you bringing a constitutional human rights-based case, or is your case another sort of case? For example, it can be a purely administrative case. You can say, here, there's a law that allows the government or a specific governing actor, the telecoms regulator, for example, to shut down the internet, but they haven't met the conditions. Or the law doesn't authorize internet shutdowns. They just thought it did, or they're just claiming it did, or they're just acting freewheeling. And that will be an administrative case and not a constitutional case. And you may find that, for example, if ISPs that are participating, let's say, in the shutdown, if they're doing so without a proper requirement from government, they haven't been ordered properly by government, they're just doing it because they think the government wants it, for example, you may have a contractual case against them because they're not meeting, you have a contract with them to supply you with internet connectivity, and they're not providing that, and they don't have a proper legal reason for doing that. They're not, there's not a clause in the contract which justifies them not giving you the service that you bought. So there are different strategies based on your, the basic nature of your case. And you need to be careful about selecting your defendants, because it's not always clear who the right defendant is. Whether government government is responsible, if so, within government, and this depends, again, on how the shutdown occurred, how open the government's being about it. If the Ministry of Communications ordered the shutdown, you know who your defendant is, but if the situation can be much cloudier than that. If you're making a constitutional argument, and Mugambi mentioned some of the possible constitutional bases, obviously freedom of expression will always be impacted. If the internet or part of the internet is not working, you're not able to engage in freedom of expression as you would absent that constraint. So that's automatically an interference with freedom of expression. Freedom of association, freedom of assembly are also very, very commonly impacted, but there may be many other types of rights that are affected. For example, equality rights. So if a shutdown is only directed at a certain group of people or a certain part of the country where certain groups live, or whatever, freedom of movement may impact it, and so many other rights depending on the impact. And I would just mention that from a freedom of expression point of view, under international law, and I should have gone back and looked at the Kenyan constitutional guarantee of freedom of expression before this this webinar, but under international law, the right protects not only the speaker, but also the listener. So it protects the right to seek, receive, and impart information and ideas. Not just impart, not just speak, but also to seek and receive. So if we think of what's happening right now, I'm speaking and you're listening, your right to freedom of expression, if this webinar was shut down, for example, your right to freedom of expression would be cut off in your right to seek and receive information, and mine in the right to impart. So that really broadens enormously. Almost anybody touched by an internet shutdown has had their right to freedom of expression impacted, because their ability to seek, at least their ability to seek and receive, has been impacted. Just coming back to the question of plaintiffs, you need to think quite carefully about that issue, because you may, let's say you're a civil society organization and your goal is to stop the shutdown, but you may find yourself with the plaintiff, and the government says, okay, fine, we're going to offer a settlement to this plaintiff while maintaining the internet shutdown. And if that plaintiff wants to accept that settlement as a legal representative of that plaintiff, you're legally bound to act in their best interests. And if they want to accept that, that may terminate your case. So you need to think very, and you don't want that sort of thing to happen. So you need to think about, is it possible for civil society organizations to be plaintiffs? They're much less likely to settle in that way. There will almost inevitably be quite a lot of people who have been impacted by the case. So bringing a joint case with a lot of plaintiffs, so that if one or two settle or whatever, you're still in play. That you need to think about that. So if we think about restrictions, and I'm going to now really focus on freedom of expression as a legal area, because to get more concrete, essentially, and under international law, and I believe it's similar under the Kenyan Constitution, restrictions on, so the shutdown is automatically a restriction on freedom of expression. Restrictions need to be justified according to a three-part test. The restriction must be provided by law, it must serve a legitimate aim, and it must be necessary to support that legitimate aim. And correct me if I'm wrong, but I believe that you have a roughly similar test under the Kenyan Constitution. Focusing first on the third part of the test, because that is often where the main arguments around shutdowns occur. Necessity means that the sorry, my screen just died. I'm not quite sure what happened there. Can you still hear me? Yeah.
Yes, we can still hear you.
Yes, we can hear you.
Yeah, sorry, I just had a very temporary internet shutdown. My screen went blank, but it's back now. The necessity part of the test, it requires that the restriction be proportional. So even if something helps national security, helps public order, if the negative impact on freedom of expression is greater than that, then the restriction will not be legitimate. The UN Special Rapporteur for Freedom of Expression has argued that shutdowns can never be proportionate. The impact, you shut down for a region or even a service, the benefits will never outweigh the benefits in terms of protecting national security, protecting public order, exams, whatever the reason that the government is putting forward for the shutdown, can never equal the benefits. For that, you need evidence. The onus is normally on the government to show that it's proportional in the first place, but you need to bring in evidence and show that it's not. So you need to think about, who is impacted. This is not just your your plaintiffs, but you can bring in usually wider, in a constitutional case, wider evidence than that, and show, how everybody was negatively impacted by this thing, and prove that it wasn't proportional. Shutdowns are by definition a form of prior restraint. So you're stopping speech before it can go out. Under international law, prior restraints are looked upon with the greatest degree of suspicion, and the government has the greatest burden to justify prior restraints because they are the most oppressive, most extensive interference with freedom of expression. So it's important to bring arguments of that. And of course, shutdowns are by definition indiscriminate. So under the necessity part of the test, you also have to show that this was the least intrusive way to protect national security, public order, whatever the government is claiming it needs to use the shutdown for. Shutdowns are untargeted, they're indiscriminate, and there are ways to targetedly block or control negative speech or harmful speech. So again, the indiscriminate nature of the shutdown, again backed up by evidence, can be an important part of your argument. In terms of provided by law, that requires not only that there is a legal basis for the shutdown, so if there isn't a legal basis for the shutdown, then both on administrative law but also on freedom of expression, you can only restrict freedom of expression if that's done in accordance with a law that authorizes that measure. But provided by law also requires that the law not be vague. So if the law sort of grants too broad discretion to government actors to shut down the internet, that is not okay. That will fail on the provided by law. And also if it gives too broad discretion to officials. And interestingly, in 2020, the ECOWAS Community Court of Justice held that a shutdown in Togo was not legitimate because there was no legal basis for it, but it held that on a freedom of expression argument. So that's an important part of it. And also the legitimate aim, the restrictions on freedom of expression are only legitimate if they serve to protect one of a limited list of legitimate aims. Those are national security, public order, public health, public morals, and the rights and reputations of others. Often governments claim national security or public order when they're shutting down the internet. I mean, they can make claims anytime they like, but courts should scrutinize those claims. They need to show that the shutdown actually is in service of national security, that that's the real aim, and that the aim, for example, is not to crush dissent or to do something else which is not legitimate ground for shutdowns. I've talked for quite about 30 minutes now, so I'm gonna stop with that. I mean, there are a lot of points that I could make about advocacy strategies around shutdowns. I've been talking mainly about the legal strategy, but the advocacy strategy, there's a whole complexity to that too. But maybe I'll stop now and leave that for questions later on. Thank you.
Great. Thank you so much, Toby, for that run through. And perhaps Dr. Mugambi, what is the, looking at our legislative framework, are there any loopholes that the state would use to justify an internet shutdown? And also, how can we partner with the private sector, especially internet service providers, in the event that we face an internet shutdown?
Okay, I trust you can hear me. So, I mean, we don't have a law that specifically provides for internet shutdown. But what has happened in the past, and I love the fact that Toby has mentioned the issue of freedom of expression. And over the last 10 years in Kenya, there's been a lot of litigation against provisions of the law that limit the right to freedom of expression. For example, you remember under the Kenya Information and Communication Act, the provision on abuse of a telecommunication device, that was declared to be unconstitutional. In another case, undermining the authority of a public officer, that was declared unconstitutional, using the proportionality test that Toby has talked about. The issue of criminal defamation was also declared to be unconstitutional. And also sending lascivious or explicit images under Kenya Information Communication Act, also declared unconstitutional. And all these decisions by the courts were premised on the right to freedom of expression. And if you look at a lot of decisions around the world that Toby has mentioned, has pointed to, is that the biggest basis, the crux, the pillar of this litigation is on the issue of freedom of expression. Even I'm sure a colleague from Uganda will talk about the litigation that happened at the East African Court of Justice challenging the internet shutdown in Uganda during one of the elections. But what we are seeing in Kenya is that, of course, it's not a remote possibility that this internet shutdown could happen. But as I said, for example, the example I gave of Telegram is that there's not been a public order to shut down this. As happened, for example, in Sudan, one of the internet shutdown in Sudan, it was a public declaration. And then in Sudan, what Toby mentioned, those so one lawyer went to court and said his internet was he didn't access to the internet, and he was the only person given a remedy. But then he went to court and said, no, I'm not the only one. There are many people who are experiencing this. The same happened in Zimbabwe, where those, I think when there were troubles during the first years of Mnangagwa, and the internet shutdown was there. But the fact was that it was proven that the minister of I think it was Information Communication Technology or Internal Security, had no legal basis to issue this to issue the notice for the shutdown. There's nothing in the law. For example, for us, when you look at the Kenya Information and Communication Act, there's no provision within that act that provides powers to the cabinet secretary or the regulator to order an internet service provider to shut down the infrastructure. But I say, I mean, we're looking at a lot of executive orders, if I may call that them. The executive orders, for example, that are done contrary to the law. I can give an example. So recently, the executive director of the Private Security Regulatory Authority, under the Private Security Regulations Act, under Section 48, purported to issue an order to all private security companies to collect and hold identification documents for anybody who was accessing short-term accommodation. And when you look at the act, there is nothing within that act that provides this executive director or the in charge of that authority the mandate to issue such such a notice. So it's possible. I mean, people could there are people who could circumvent the law to issue orders that are akin to either partial or full internet shutdown. But nothing, so far in my research, there's nothing I found in our law that will provide powers to anybody to either throttle or shut down communication infrastructure in Kenya. But notwithstanding, when you look at, for example, the International Covenant on Civil and Political Rights, within it, I mean, there are principles internationally about where a country can declare that their derogation can make derogation declarations. But Kenya, we've never reached that. We've never reached a point where Kenya has had to make a declaration for derogation of, let's say, the freedom of expression or freedom of movement or political rights. But it is a possibility and is an avenue that is available. The good thing is that the courts have been very proactive in terms of protecting fundamental rights and freedom, especially where the government goes overboard. Now, on private sector, some of the challenges, for example, when you look at when you study the case of Uganda, and sure our colleagues will talk about it, Uganda, Sudan, Togo, and Zimbabwe, is that this private sector, the internet company providers, they say we've gotten an order from our regulator. Our regulator has ordered us to throttle the internet, and here people are looking at licensing, businesses, etc. So they actually do it. And the interesting bit is that perhaps maybe Toby might know, but I've not come across a decision or a case whereby it's the private sector going to court and saying, hold on, you know, this internet shutdown, whether full or partial, is affecting our business, and it is our socioeconomic rights or economic rights or right to property is being infringed. And you'll find that a lot of litigation, just as Toby mentioned, a lot of this litigation is done by civil society organizations. The one in Zimbabwe, I think it was by the lawyers association. The Togo one, I think it was Amnesty International, Article 19. I can't remember the other one. So you find that it is this civil society organization that actually go to court, and everybody benefits. And a lot of time, because in Kenya, you see what has happened in Kenya, since 2013, when we had elections in 2013, then in 2017, then in 2022, we've always had petitions ready to go to court just in case there's a shutdown. We always think that there'll be a shutdown, and that's why you can remember last year, in the last election, the cabinet minister for interior and the one for ICT were constantly saying, no, 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 we'll not share the internet. But there was a fear. But all you find in Kenya is that there are already organizations and individuals that have already carried out the research, are prepared, and they have the strategy that Toby was talking about, so that in case there's a shutdown, this is how we'll go about it. We have the limbs of arguments. We have potential petitioners, not just who know who the defendant will be. But the issue of private sector, just to conclude, is just to say, I don't know whether there's a country that has sorted that out, because private sector always fears that in the event that they get into these murky waters of litigating internet shutdown, that this may affect their license. But you'll find civil society and individual citizens, like the case of the lawyer in Sudan who went to court to challenge the shutdown, and he succeeded as an individual and also finally for everyone. Private sector just shies off, basically.
Great. I love that you've mentioned that before every election, you always have petitions ready just in case, the country experiences shutdown, then you can move to court. And I think that's a wonderful strategy to always be prepared. I don't know if Michael has already joined us. Michael?
Yeah, yes, Magdalene, finally.
Great, welcome. Maybe you can start by introducing yourself and giving us, in the context of Uganda, how have you, litigated against the internet shutdown that you faced? Welcome.
Thank you, Magdalene, and colleagues. My name is Mike Aboneka, an advocate in Uganda. I joined in late because I was attending to something else. And yes, but I'm glad to be here. I am a human rights advocate in Uganda, dealing mostly with human rights issues and constitutional law issues, but pertaining mostly, I have a bias on digital ID rights. Just to say that I just put a disclaimer that I have participated in most of these matters, not directly in court, but supporting the colleagues that have been filing these matters. We've gone through as a country waves of internet shutdown. I think the first one in 2016 elections, and then towards the 2021 elections, and we've had colleagues, unwanted witness, go to court over that, and I know that the same unwanted witness went to court over the same matter. Now, and I know a colleague here, Morgan Mohindo, was a party in one of the cases, I think for Facebook as well. Now, the common thread that court seems to take, and I agree with the previous speaker, I forget his name, the one before Mr. Mugambi, about choosing the right plaintiff for the right parties. Now, in most cases, I'll just pick one of them, which is the unwanted witnesses versus Attorney General, where the unwanted witness, a civil society organization, takes to court the companies that are supposed to provide internet, and then they are saying that for them to shut down the internet, it's actually a violation of rights, of the right to expression and the rest. Now, court on such matters has really taken the position of throwing the matter on technicalities, and not really giving us the benefit of diverging into the merits of the case. So in the case that I'm discussing, court, the MTN, all the other ISPs put up an objection and say, no, this is a company. Can it show And under Article 50, because Article or any organization that feels like your right is about
I think we're losing Michael.
just vaguely, rubs you off
Michael.
an opportunity for court that violates, and I see was here on the issue.
I think we are losing you, Michael. Can you hear me? I think we've lost him. So in the meantime, if you have any question, any of our participants, you can just add them on the chat so that Ugando, who says that for the government, it's usually more of a reactive approach than a proactive approach, especially after a catastrophe has struck, and that's indeed true.
Magdalene, can I just comment very quickly on Mugambi's point about companies?
Great, take it away.
Yeah, so I mean, I think that's interesting. A couple of things. I mean, in theory, companies absolutely could press back on these things because their ability to engage in commercial activities is being impacted, and their bottom line, as it were. I'm not sure that I know of any case which has been spearheaded by the companies, but I haven't studied all of the cases internationally. It's possible, but my experience with that is that in a lot of times, companies don't want to challenge governments that directly and that forcefully, just because they kind of rely on good relations with government in other ways. But of course, in a strong rule of law context, that shouldn't be the case, and they should do that. I also think that I mentioned briefly this idea that you might have a contractual case, that the users or the customers of a company might have a contractual case against the company, and I just want to, where the government orders a company to close off the internet or throttle the internet or stop providing services or whatever the specific order is. What we have observed, and we've just done a significant piece of research on the reactions in Asia, and what we have observed is that even the biggest companies in the world, they rarely challenge governments, on the legality of those measures. The government claims it has a legal basis, and the companies go ahead with it. But what I think would be an interesting test case was where the government didn't engage in a fully established legal order against a company, but it just kind of made it clear to companies one way or another that it expected them to shut down, and the companies complied with that. I think that and those, that does happen. That certainly happens very, very frequently, for example, in terms of companies providing access to data. That's not a shutdown, I understand, but it's another kind of human rights issue, invasion of privacy, and in many countries, governments ask companies for personal data, and they just give it. Even in the United States, as we know from oh, his name's escaping me now, but the whistleblower that fled to Russia. So, I mean, and when companies do that kind of behavior, I think that you could have certainly a contractual case against the company, because they, they're not, they're required to obey the law, but they're not required to follow the wishes of the government in ways that are abusive to your rights. And so I think that could be grounds for quite an innovative legal case. In other words, you take a case against the company, either possibly a human rights case, but at least a contractual case, saying, you shut down the internet without a proper order from the government, and you're not allowed to do that. Just a thought.
Just to add to what Toby has said, so you'll find that a lot of the reports that have been done, whether it's by CPS, Access Now, Article 19, they usually give the economic, how much has been, the economic damage that a shutdown has caused. And perhaps, in Kenya, we haven't experienced this, but perhaps part of our strategy, maybe in a possible litigation, if a shutdown was to happen, that could rope in some of these private sector, is to, they might not be the internet providers, but you can rope in MSMEs, which you can say, this is the kind of loss that they've experienced from this shutdown, and just to prove that issue of the economic point, because as I said, a lot of these cases, when you research, most of them, the limp that usually succeeds is the issue of freedom of expression, because I think it's one of the easiest. And even the African Union has had these declarations that you need to keep the internet open, because one of the core needs for this is because the right to freedom of expression.
Yeah, I fully agree with that.
Yeah, great. And before I give Morgan a chance to speak, perhaps Dr. Mugambi, I could ask, what are the limitations or potential risks that are associated with using litigation as the only tool to advance digital rights? And are there alternative approaches that we should probably be considering?
I think Toby was about to talk about them, but let me talk about what has happened. So, so you remember around 2013, 2014, I think what can I say, the initial years of the Jubilee administration, there are a lot of bloggers who used to be arrested. And they used to be arrested on this undermining the authority of public office, criminal defamation, and that kind of thing. So litigation worked to that extent, but there's something else that we realized because together with Article 19, the Bloggers Association of Kenya, we came up with a program that trained bloggers, journalists, and lawyers about the intricacies of digital rights. So going through all the fundamental rights that may be affected, what we generally call in a port digital rights. So what that did is that it provided a critical mass of journalists and bloggers who understand what digital rights are and are able to research, write, and report on it in terms of. So, for example, if a blogger is arrested, they know what are the key arguments that need to be set out there. Then something else, as I say, that we did also with this was in support. I think Article 19 was there. Media defense from the UK was there. That we trained lawyers, and some of the cases that are in court now that are for the defense of digital rights in general, whether it's freedom of press, freedom of expression, etc., are lawyers who are trained within that. Within that course that we held. So it's also creating a critical mass of people who understand, so that it's not just one organization or it's not just one person who has the technical know-how of how to bring these matters forward. And I think, like Toby mentioned, is that it's very important to decide, especially where the shutdown relates to a political process. You'll find, like in the Togo case, I think it was very it was very targeted to have the Amnesty International, for example, and other civil society as the petitioners in the ECOWAS court, because what that does is that it avoids any repercussions for individuals. Because if you're an individual petitioner, you may find it rough, because agents of the state who are pro the shutdown or whatever action the government is may come against you as an individual. So that's why it's usually advised that some of these very high profile kind of cases, especially in shutdowns, and this has happened, I think happened in Uganda, in Togo, in Cameroon, etc. The shutdown that has been there, especially in the English-speaking side of Cameroon, is that you bring civil society, several civil society together, and they become the petitioners, and that usually protects against reprisals that may happen. And also having security measures in another point that you need to note: in some of this litigation, you need security measures. The kind of apps that you are using, the kind of emails, you need to use encryption tools, VPNs, etc. So they also need a strategy about the people supporting the case and their security, because in some cases you might find that even the lawyers themselves who are representing the litigants are targeted for violence or for intimidation by the state.
Great. Morgan, perhaps you can now share your experience suing Facebook. Morgan, are you still with us? I think we've lost him. Just maybe a question for Toby. Just paint a picture for us on using regional courts to enforce digital rights. How is that going?
Sure. I mean, you're very lucky in Africa to have a series of regional courts that will deal with human rights issues, and in fact, they have become some of the more important fora for dealing with human rights issues in Africa. It's a shame that not more African countries have signed up for the jurisdiction of the African Court on Human and People's Rights, though, which is the fully regional court that I think would be quite would be good to see more courts engaging with that regional court. I mean, at any point that you're thinking of going to an international court, whether it's fully international or regional or sub-regional, normally you have to. One of the challenges with that is that you have to exhaust domestic remedies, which means you have to go through your own courts before you can go to that court. So you have to go up through your court system, and of course that can take quite a lot of time and quite a lot of resources. But there are ways to get around that if the remedy that is formally available before your courts is in fact illusory or impractical, either because excuse me, those courts are simply not independent, not functioning properly in the first case, or because they have already essentially decided a similar issue. Then you can kind of skip up to the international courts. But I mean, I mentioned the Togo case before the ECOWAS community court of I forget the exact name of it, the ECOWAS. Go back to the notes I have it written down. The Community Court of Justice, sorry, and I mean that was a very seminal case in Togo. They held that the government did not have any legal basis for ordering the shutdown, and that therefore it had been a breach of rights, and that that it was a restriction on rights which wasn't justified, so it was ultimately a breach of freedom of expression. And I think that was quite quite impactful. And of course, when you have a win at a regional court or a sub-regional court, the visibility of that is enormous. I mean, far more people, I guess, know about that decision than anyone would know about, let's say there had been a positive decision before the Togan courts. I don't think that would have traveled anywhere near as widely and had the same level of impact. So, of course, the another challenge, though, with regional or sub-regional courts is enforcing the decisions. Not, governments don't always respect those, although there has been a reasonable track record across Africa. I believe, I haven't done a study, on all of those kinds of decisions, but the criminal defamation cases that have come out of some of the sub-regional courts in Africa, for example, holding that criminal defamation is not legitimate. Those have been very, very impactful, not only in the countries that they were applied to, but also in other countries, and then senior courts in other countries have followed those decisions. So, I mean, I think that the sub-regional and regional courts, the impact of those decisions can be quite significant in a lot of different ways. As I just mentioned, for example, a senior court, the Supreme Court, for example, of a country that wasn't affected directly by that decision, can still take that into account, and they're much more likely to be aware of that and to follow that. So I think that pursuing that sort of international litigation, it does take a lot of resources. You need to make sure that you prepare your case very well, that you have strong lawyers and things like that. But the impact is also very significant. So definitely an important part of the strategy.
Great. I see Morgan is back with us. Morgan, take it away.
Yes, Magdalene. Thanks for this opportunity. Well, I didn't prepare for this space, but thanks for the beautiful conversation that you're having and wonderful insights from the panelists. I happen to be one of the applicants in one of the applications challenging the continued Facebook shutdown here in Uganda. And that was around 2021. Yes, around there, that's when we filed that application. And I thought my colleague, our NECA, Michael, was going to really have a proper discussion on this. But from my experience, especially when you're dealing with strategic litigation, and obviously you're going for the government, a government or a state that itself is interested in the shutdown of that part of the internet or the whole internet, you're likely to face a lot of challenges or pushback from it and its own institutions. So that's the exact story of myself and my lawyers of what we faced in the Ugandan courts. First, the problem was even fixing that matter for hearing. It was a very big challenge getting a date to make sure that the matter is heard. The date was heard. We are slapped with a preliminary objection raised by court itself. So it was the judge who raised the preliminary objection, and the question was all about locus standi, whether me as a person, I had the authority of representing all of Ugandans in order to qualify that my matter is a public interest matter. There's a disturbing rule of procedure here that we have in Uganda that is confusing, and if up to now courts have not really sorted it out, especially when it comes to matters of human rights, and it seems to be an intentional rule, and it requires, for example, that if you're claiming that you're bringing a matter under public interest, then you must apply to the Constitutional Court. And when you look at the jurisdiction of the Constitutional Court, it is not necessarily there to enforce rights, but for constitutional interpretation. That's its jurisdiction. So now what happens is that when you take such kind of a matter to the Constitutional Court, or if you make an application to the Constitutional Court will send you back to the High Court, because the argument will be this is a matter of human rights enforcement, and the High Court has the jurisdiction to hear that kind of application. So you find yourself, you're in the middle. You go to the High Court chases you on the argument that it doesn't have the jurisdiction. You go to the Constitutional Court, the same argument is made against the application, but that's the general situation, especially when it comes to human rights enforcement matters in Uganda, and it seems to be a deliberate position of the law or provision of the law that is intended to curtail access to justice in Uganda. That's the broad overview of it. But obviously, there are very many human rights enforcement suits or applications that have been kicked out of court on that specific technicality. So back to the human, that one speaks generally to the aspect that I'm talking about, that when the state is interested, for example, in matters of now like internet, we have a president who keeps on castigating internet and other social media platforms. Obviously, to many social media platforms is internet. We begin to really start interacting with very many parts of the internet because of the Facebooks of this world. So if you don't really have Facebook, some people up to now, they may not tell you that internet is beyond just the Facebook as a platform. So, but you have a president who keeps on telling you that these are platforms of rumor mongering. These are platforms that are that are pushing for the Western agenda, and that agenda is against him. So at the end of the day, he's in order to protect his power, he has a very big interest, and he doesn't care whether the whole of the internet is shut down or a platform like Facebook is shut down. So those are some of the challenges. Now, those are issues of power, the state power, and then the business side of it. So at the end of the day, it doesn't matter to the president, for him and the whole government. It doesn't matter what the rest of Ugandans are using these platforms for. Because when you look at that application I made, I got several affidavits from young people who are obviously advertising their businesses using Facebook platforms. Then the guys who are running campaigns, presidential campaigns, using those social media platforms, and the information they give you is that because of the shutdown of the internet and also Facebook itself, some of them were unable to sell to their clients, and that also undermines the aspect of the right to practice one's trade and all of that. That's an economic right. Then also issues to do with civic participation. People stopped receiving information in regard to how their candidates were performing in an election. So at the end of the day, there was a curtailment, unjustifiable curtailment of fundamental rights, including the right to access to information, sharing views and opinions about an electoral process. There are issues to do with accountability, because now you don't have internet, you don't know what is happening. People were supposed to be sharing information in real time, especially when it comes to returning results from their own polling stations, as a form of having alternative information rather than just relying on official and government information from the polling stations. But at the end of the day, the people themselves were denied that kind of opportunity to participate fully in that electoral process. So those are some of the legal issues, obviously the human rights abuse that came along. So when the strategic litigation itself is a very important tool, but again, you have to look at the context within which you're going to utilize such kind of a tool. In Uganda, I can say that I was a little bit frustrated, because when we lost the case, obviously we appealed to the Court of Appeal, but up to now, we've pushed for hearing date. We have never gotten one. We are about to go for another election, and then you really don't have any pronouncement of court on such kind of very important aspects. And some of the arguments that we make in that application is that one, because we didn't go for the whole ecosystem of called the internet, we only went for a platform called Facebook. And the argument we are making is that there must be a specific law that gives whoever or whichever authority of government the powers in the first place to shut down the internet. That part, even though it's just a single part of the internet, there must be a specific law. And then that law must also provide for procedural safeguards. For example, there must be a requirement of a judicial process or oversight over an internet shutdown. So someone cannot just base on speculations like in the Ugandan case. There are a lot of speculations, including speculations that Facebook and other social media platforms were going to fuel violence or electoral-related violence. So basing on that speculation, the Attorney General made an argument. I remember when they were replying to our application, giving several reports, the intelligence reports indicating that there are people who were fueling that were planning to fuel electoral violence, basing or using those social media platforms. And again, there's one important argument that the Attorney General again makes in his response, that there are specific social media accounts that were being used by the bad people, the bad elements, and the argument we are making is that you cannot use a sledgehammer, obviously, to kill a mosquito if you know those targeted, because they even listed the accounts, and most of them were opposition guys, and the point was, if you know all of those accounts, why wouldn't you go for those specific accounts, block those specific accounts, and then leave the rest of Ugandans to enjoy their right, their freedoms, freedom of expression, and all other rights that they can enjoy using such kind of platforms? Why would you have to lump everyone in? And obviously there was no counter argument around that. And we thought that was a strong case that we had made, but I can assure you the case, we lost it on technicalities. Obviously we're on appeal, and we're still fighting. But one of the things that keep pushing us and myself more is that we would need pronouncements on such kind of litigation, so that it can inform how states really interact with such kind of platforms, more especially when it comes to an electoral processes or election season itself. Yeah, so that's what I can say for now, unless there are specific questions that you do really want to ask me.
I love that you've touched on the question of judicial independence vis-a-vis political interference when it comes to using the court system. And maybe I can ask you, just post the litigation, what next? Have you seen any impact of you filing this case? And are there any policy changes that Uganda has experienced?
Not really. Not really. In fact, somehow I even regret why I filed the application, because it set a very bad procedural precedent that is being relied on to frustrate other human rights applications. That's the bad side of it. But obviously the conversation continues, and I like that this conversation is happening. Though I can see most of you are Kenyans, it's not a conversation we're having here in Uganda. Obviously, it's something that we had around February and March of 2021, but it's a conversation that even civil society organizations are not engaging in. I can understand the apathy of most of the civil society organizations in Uganda. Again, it goes back to what most of you have been talking about, the licensing regime of all of these sectors, right from the civil society to the internet service providers. The licensing regime, I always call it a floating charge. over these entities. So somehow it is a tool of silencing people who are supposed to be coming out and fighting. I know Michael is around here, but he will tell you that contrary to what most of the speakers here are saying, it's better here in Uganda to fight as an individual than even as an organization, because you as an individual, obviously, there's less to go after you. But if it is an internet service provider, it knows that its license is supposed to expire in a specific period of time, and the regulator has an option of renewing it or not. Then also you have civil society organizations, same story, being they have this person hovering, the regulator hovering over them all the time. We have had those situations where most of them have been they have issues with the regulators. So those are some of the issues. When you talk about judicial independence, I can assure you, if the president has an interest, more especially in a matter what they call national security, then it becomes so hard for the judicial officers to maintain their feet, more especially in the context of Uganda. So it becomes really a very big challenge. And then the whole question of what is the space of strategic litigation in Uganda? All I can describe it is like a walk on eggshells.
Thank you so much, Morgan. I know it was an ambush, but we appreciate your insight. I don't know if there's anyone in the audience who might have a question. You can just unmute and ask our panelist.
Can I ask Morgan a quick question?
Yeah, sure, Toby.
Yeah, so Morgan, I mean, I'm aware of the challenges for, as you mentioned them as well, for freedom of association and civil society in Uganda, and also for freedom of expression and media freedom. But when you launched the case, did you explicitly plan it to have accompanying it an advocacy component, so that you know, in addition to making those arguments about the impact in court, you also kind of tried to popularize those that information to the general public? Because I think in a challenging context like Uganda, as you have very aptly described it, you know, you really need a multi-pronged approach when you engage in strategic litigation, to basically to attach to that as strong as possible of an advocacy strategy, so that you can at least impose, you know, other costs to the government for opposing you. I'm just wondering whether you did that in that case.
No, not really. We really didn't have too much of out of court sort of engagement, but we really engaged a few civil society organizations. Some of them, obviously, it's not something that we are really interested in. And it's also in Uganda, it is still a small space. You don't have very many actors. Then also some of the actors that are in, some of them are not really interested in litigation because of the factors that I really told you about. But also strategically, we didn't really want to make it look like a popularized case and throw it outside there, make noise about it, because somehow the courts, we thought, in our, at least from the experience that we have had with some specific strategic litigation cases, is that you can silently go to court, make the judge or judicial officer comfortable by giving you a decision in silence, and it creates that kind of impact. So that's the wrong impression, obviously, that we had. We thought that we can silently go to court, give the judicial officer that kind of environment of thinking that even when they make that decision, it may not come with big consequences. So at the end of the day, we are wrong in our own judgment. So at the end of the day, we thought maybe the judicial officer was going to be very comfortable because this is not a highly political case or popularized case, so they would easily buy our arguments that we are making. But unfortunately, that didn't happen. So it was part of the strategy that the case doesn't take some of those strategies that you would really want to suggest. But thanks for that very good and wonderful question.
Well, thanks for that excellent response as well. And yeah, I mean, I think the problem was, I mean, you know, when a government is engaging in a shutdown activity, it's almost automatically high profile, and you know there are big interests behind it. It's very difficult to, and I don't know whether the shutdown was ongoing as your case was proceeding, but if so, then you know the court would have to stop an ongoing shutdown, which presumably would have been quite visible. So I think probably the silent, softly approach, as you described it, is not so easy, at least in a case like this.
Thank you. I am still inviting questions from members of the audience or comments. Anyone, just feel free to unmute and ask away.
Magdalene, I see there's a hand up.
Yes, Michael.
Yeah, sorry, mine may not be a question. I just wanted to, I'm sorry, my rights to internet, to access to internet have been taken away for some minutes. There are just three things I just want to mention. That there seems to be a sort of conspiracy in terms of this issue of internet, because it involves the economic aspects, which is of course the multilaterals, especially for the economic social rights, be it education and the rest. Courts seem not to want to take a firm decision on the same. For example, we've just been pushing court to, to oblige the Minister of Education to regulate fees, because the law does so. The court says, yes, she has an obligation, but we're not going to force her to do that. So there's that increasing kind of subtle ban or moratorium on such matters that come to the economic and social cultural rights. But I know that the East African Law Society has a matter before the East African Court of Justice over the internet shutdown in Uganda. We'll need to just find out how far that has gone. But the common thread, both in the constitutional petition and at High Court, is for them to say the principle of proportionality, and I think Toby touched about it, and they say, the shutdown in Uganda was just, especially the internet, was just for a fortnight, and therefore it is not as it was in the Indian case, where it took on for some time, where and actually the constitutional petition, both the constitutional petition and the High Court judges adopt the position of the Supreme Court in India, where the court is saying that if the suspension is indefinite, then therefore there it can be impermissible, but seems to suggest that if it is not definite, therefore it is thereby permissible. There's a big problem with that, is that you do not know when the internet will return. They have not said the internet will come back tomorrow. It's just like power shutdowns in other parts where we are, they give you an alert and say there will be a power shutdown tomorrow. So it is definite, you kind of know. But we do not know when the internet shutdown will be lifted. And of course, these cases come after the internet shutdown has happened for courts, for them to use that. Lastly, is for me the issue of the derogation in terms of, I think Morgan mentioned it, when you're going to derogate the right, what must you do? And I keep arguing today in Uganda that using Facebook is not illegal, because there is no law that stops me from using Facebook. So I take the activism approach to that and tell everyone, if you're able to access Facebook in whatever way, access Facebook, because there is no law that bans Facebook. But look here, you may need a VPN and you may need extra bundles to access Facebook in Uganda. Because even police communicates on Facebook and the rest. So we say police, if police you're communicating on Facebook, you cannot arrest anyone, because anyway, there's no law banning that. But even to trace a communication from Ugandan government to Facebook to say close down or Facebook or whatever, or to UCC, you rarely see them. Because one of the things we got to court for, and I hope maybe the colleagues in Kenya will be successful, is for discovery, to find out if what form of communication does government take. Do they just call MTN or internet service providers and ask them to switch off directly, or they use their their communication entities to direct them? And when those communication entities are sort of communicating the illegal directive from the executive, do they write them down? Do they send an email? Do they just make a phone call? And it will be good to find out that. So lastly, and this is my final last, Magdalene, then where is the solution? Most of this, I think, has to be at the political level to continue pushing the advocacy. And I know that Toby asked Morgan about the advocacy component versus litigation. We try as much as we can, but there's general fatigue of how much can we do? And there are very few litigators in Uganda that are taking on public interest on very serious matters because of the general fatigue, because of the kind of rulings that courts give you. And I'm dealing with one case where the judge picks out, we are 3 applicants, and the judge picks up one applicant and slaps costs on that applicant because that applicant has been problematic or is filing cases. So there's also the issue of victimization, which we are going through, but I think that we need to continue. Lastly, is the companies. Is it possible to continue engaging the companies on the sideways and show them the impact of such a law on them, like the Computer Misuse Act? I think I remember we're engaging the companies and telling them, by the way, if people are finding it risky to be on the internet, so they'll not be able to buy your data, and therefore you're going to lose this much. I just don't know how much you can go with that. But I think that the fight just has to continue. And I am hoping probably that if we have a matter such as that from the ESCJ, if we have a decision, hopefully it will be helpful. But maybe we need to explore other mechanisms, like maybe the African court and the rest, just test out. And I hope that maybe if Kenya pushes for this and we get a jurisdiction, jurisprudence from Kenya, probably it will help. But as of now, we're a bit stuck. The Constitutional Court has already given its own ruling and saying no, shuts down and all these things within the Supreme Court of India judgment is fine for Uganda as long as it is not indefinite. So we are still around there, but we hope that one day we'll get out of this. Thank you.
Thank you so much, Michael, for that insightful discussion. Maybe as we wrap up, I can invite Dr. Mugambi and then Toby to give their closing remarks.
Thank you so much, Magdalene, for having these sessions, and thank you to Toby, Michael, and Morgan for their insights. I think for me, it's just that, as I said, it's not a remote possibility that a shutdown can happen in Kenya. But the fact is that we are prepared in the event that it happens. I think the insights from Michael, Morgan, and Toby will be critical for the colleagues in this forum, just in case they decide to either represent litigants or they themselves to become the litigants in the event of a shutdown. Thank you so much.
Thank you, Dr. Mugambi. Toby?
Thanks so much for inviting me to this this discussion. I thought it was very, very interesting. I should perhaps a little bit shamelessly put in a pitch for a free course that we developed in line with Advocacy Assembly on litigating internet shutdown. So exactly on the topic of this this discussion. It's supposed to take about, okay, thank you, about an hour and a half or 2 hours to go through. So it's not, not a very heavy course. And a lot of the points I made and some of the points that I didn't make, because I didn't, talk too much about the advocacy side of things, are set out in that course. So if you're interested, I would definitely encourage you to do that. And also just to say that, Magdalene, feel free to share my email with participants, or I can drop it in the chat if I get a chance. If you are engaged in internet shutdown litigation, or indeed other kinds of litigation on freedom of expression issues, feel free to reach out to us. We don't always have the bandwidth to support litigation. There's a lot of litigation. Thank you, Magdalene. A lot of litigation going on in a lot of countries around the world, but Kenya especially is a propitious jurisdiction for this litigation, in our opinion, because you do have pretty independent courts. They're prepared to come to innovative sometimes decisions. So that's a great place to do litigation. And of course, not only in Kenya, also in Uganda, even though the environment a little tougher over there. So please feel free to reach out to us, and we at least will be able to provide you with some international law materials that are relevant for your case. So you may wish to integrate them into your brief. I didn't talk about that too much, but that's another thing. We talked about litigation before, sub-regional, regional, or international courts, but you can also integrate international content, international standards into your national court arguments, because international law is in most jurisdictions has relevance in one way or another. It depends on the jurisdiction. So please feel free to reach out to us.
Thank you so much, Toby. As I mentioned at the start, I was an Internet Shutdown Advocacy Fellow with Advocacy Assembly 2023. Advocacy Assembly is a free website repository that has a lot of courses and information on all these topics around digital rights, cybersecurity. I've dropped the link to the website there. So if this is an area that you're keen on progressing, on learning, you can always go there and learn as much as you can, as well as download those certificates. So I wish in a special way to thank all our panelists, Toby, Dr. Mugambi, Michael, and Morgan. We appreciate your time and also the insights that you have offered. I hope everyone who attended this webinar has at least learned something. I know that I've learned a great deal from these wonderful experts. I also wish to thank the LSK Nairobi branch for partnering with us and for welcoming their members. I think Wendy is still with us. So thank you so much for your time, and that's it. Thank you. Wendy?
Thank you, Magdalene, for coordinating this webinar. Thank you to all the panelists and the members who attended this session. On behalf of the chair of LSK Nairobi branch, Madam Helen Namisi, I thank you all. For those who joined late, my name is Wendy Muganda from LSK Nairobi branch. Thank you all. Have a great evening.
Wonderful. And if you wish to connect with me, you can find me on LinkedIn, Magdalene Wanjiko Waidera. We can discuss more. But that's it for today. Thank you. Have a good evening. Have a good day from wherever you are watching us from.